code. I will let you know how to remember the chapter and how to link them. Okay? Don't run away. See, you cannot do everything in one day. Even I cannot do it. I always daily I decide ke I will do half an hour mein this, half an hour mein this, but I'm not able to do because we are limited with the time. We are limited with our thinking ability, right? So don't try to run away. Do it slowly. You have at least 1 month now. Still 1 month is there, so it's enough time. Dheere dheere karo. Fine. So let's start with the session. Okay. Employee State Insurance Act 1948. What is this law? What is this legislation? Let's first understand the history. So Employee State Insurance Act, this legislation actually came up with an purpose or objective of providing the social security benefits to the workers or the employees working an industrial establishment in India. It was for the first time, the first document on the social insurance, which was presented by a BP Adarkar 1943 by his tripartite conference, headed by the tripartite conference, which labor conference, tripartite labor conference, which was headed by BP Adarkar in 1943. He submitted a report. The report was a report on the health insurance. So it was BP Adarkar committee's output in the form of report called as Report on Health Insurance, when for the first time the first document related to social insurance came into the existence. This document is considered to be the precursor of starting the social security schemes in India. It was on BP Adarkar's recommendations and the suggestions made by the Stack and Rao, the Workmen's State Insurance Bill 1946 was framed. Later on, this was passed by Dominion Assembly in April 1948 as Employee State Insurance Act of 1948. The purpose of this Employee State Insurance Act was to plan a scheme of health insurance all India basis and administered uniformly throughout the country. So BP Adarkar was given a responsibility to find out or to survey or to study what all health insurance facilities are available in the country, or whatever health insurance facilities, social security facility we can make available in the country. As a result of which, ESIC Act came into the existence. The purpose was to provide health insurance uniformly around the country. So this act was one of its first kind in Southeast Asia, which marked the beginning of social insurance for industrial workers in India. The ESIC, it is an Employee State Insurance Corporation, which is constituted under ESI Act by the central government. The Employee State Insurance Corporation is responsible for administration of this law. This control by the central government, the control. So now your social security, or you can say the insurance, we have 3 lists given into the 7th schedule: union list, state list, and concurrent list. This social security matter is a matter of, or the matter which comes under the central government. It's only the responsibility of the government. So social security, especially related to the insurance, is the matter given into the union list. Who remembers the entry number? Anyone who remembers the entry number given into the union list? So because insurance, it would either it is public or private, is listed into the 7th schedule of Indian Constitution as a union list subject, it can only be legislated by the central government. Please understand. Now, whatever matters are given into the union list, the legislation related to it can be framed only by the central government. And the administration would be decided by the central government. However, the administration of this can be given to the state government, lower. The direction, delegations can be done. But all other things, what would be the schemes, what would be the benefit, how the laws would be framed, this is the responsibility of the central government as it forms the part of the union list. Is this clear to everyone? The history is clear to everyone? 55 25 नहीं है, 25 नहीं है, कॉन्करेंट है. यस पूजा, 55. ठीक है, न्यूमेरिकल हाँ करेंगे, पहले लॉ कर लेते हैं उसके बाद में. क्लियर? चलो लेट्स मूव टू द नेक्स्ट. There are the 8 chapters which you have to by heart by their name, and the schedules, 3 schedules out of which 1 has been omitted. Clear? 1 preliminary, that is your definitions, introduction and so on. 2, please remember this, cooperation, that is ESIC, Standing Committee, Medical Benefit Council. These are the 3 bodies under this law which basically are responsible for administration. ESIC, under ESIC, the members, under ESIC, there is the Standing Committee and then Medical Benefit Council. Chapter 3, Finance and Audit, CAG is responsible for auditing the complete accounts of the ESI Corporation. Chapter 4, important, kaun sa chapter, which chapter talks about contribution? Chapter 4. Chapter 5, which of the benefits are available under the ESI and which chapter talks about the benefit? Chapter 5. 5A, other than this benefits, other than the benefits given here, other than the eligible, which are the schemes for other beneficiaries? Here other beneficiaries means family member, relatives, dependents, right? Chapter 5A. 6, adjudication of dispute and claims. 7, penalties. 8, miscellaneous. Schedule, 3 schedule. First schedule, which is being omitted by the amendment of 1989. The second schedule, it is in reference with the, where it is used, section 215A, section 215B. These are the definition of permanent total disablement, permanent partial disablement. So second schedule has the list of the those disablement which would be considered as permanent total disablement in 15A, for 15A, and 15B, which would be considered list of those disablement which, or the injuries which would be deemed to be a result into the permanent partial disablement. Third schedule, which applies to section 52A. This here we are going to study occupational diseases. So list of the occupational diseases which have part A, part B and part C. So compensation is given in combinations. Would you be able to remember the chapters and schedules? 8 chapters. Chapter number 4, chapter number 2, 3, 4, 5. Really very important. Others, even if you don't remember, fine. Then schedule, all are important. Is this clear? Moving ahead. Keep on replying. Employee State Insurance Act 1948. Chapter number 5 talks about benefits. Employee State Insurance Act came into the existence with the purpose of providing the social security benefit, especially with an objective of insurance. What is insurance? Where the contribution is required. 2 types of social security is there, assistance and insurance. Assistance is no contribution is required. Insurance is contribution is required. So act to provide the certain benefits to the employees like sickness, maternity, employment injury, and to make a provision for certain other matter related to it. Whereas it is expedient for the certain benefits of employees in sickness, maternity and employment injury, and to make a provision of certain other matters relation to. So it is the responsibility of the employer, or rather within this law, it is responsibility of employer to provide this all benefit. This act is called as Employee State Insurance Act of 1948, extends to whole country. It will come into the force as the date may be decided by the central government. this date can be different for the, there can be different dates for the different provisions, different dates for the different parts of the country, different dates for the different area. For the first instance, the ESI Act will be applicable to all factories, including the factories belonging to the government, other than the seasonal factories. So it is applicable to the factory, government factory, but not to the seasonal factory. However, the appropriate government, after consultation with the corporation, and where the appropriate government is the state government with the approval of central government. So appropriate government is central government. Then central government will in consultation with ESIC corporation. And where the state government is the appropriate government, it will ask for approval from central government. After this, giving 6 months notice in the official gazette, the provision of this act may be extended to establishment, any class of establishment, industrial, commercial, agriculture, or otherwise. Clear where it is applicable, how it is applicable. Section 2(1) defines appropriate government. So central government would be an appropriate government for the establishment which are under the control of the central government. Railway administration, a major port or a minor oil field. State government, all other cases, state government would be the appropriate government. Section 2(3) defines confinement. Confinement is the labor, a labor which is resulting by a labor resulting in the issue of leaving child, or a labor after 26 weeks of pregnancy resulting in issue of the child, whether alive or dead. Anything which happens after the pregnancy, after delivery, that is confinement. Contribution, the amount or the sum of the money which is payable to the corporation by the principal employer and employees in order to get the benefit of the schemes under benefits of the schemes under this. So contribution is to be made by both employee and employer. Corporation, the Employee State Insurance Corporation set up under this act is called corporation. This is important. Dependent. Section 2(6)(a) defines dependent. Okay. Section 2(d) under the Employees Compensation Act defines dependent. Here, section 2(6)(a). So for a deceased employee, deceased means one who is no more. Parental grandparent, if the parent are not alive, would be dependent. Widow or widower, parents, father, mother if widowed, son, legitimate, adopted, illegitimate, all minor. Son or daughter who have attended the 25 years of age but are sick or infirm, not able to take care of themselves. This is 18 years in Employees Compensation Act. Daughter, legitimate, adopted, illegitimate, unmarried. All the cases unmarried. But if she is married, minor, or widowed, minor. Married, widowed, both case minor. Daughter-in-law, widowed daughter-in-law. Son was there, son died. So what? Daughter-in-law, who is widow. Minor child, even the daughter-in-law is not alive, son is not alive. Minor child of predeceased. Sister, widow, who is minor, married, who is minor. Both widow and married, minor case. Minor brother. So he is minor brother. Is this clear to everyone? What is the definition for the dependent? Very, very important. Let's move to the next. Section 2(8) defines employment injury. Important. What do you mean by employment injury? Any kind of personal injury which is caused to an employee, or any kind of personal injury which is caused to an employee or a workman due to any kind of accident or occupational diseases which is arising out of or in course of employment. But this disease or the accident or this personal injury which should be an insurable employment, means wherever the employment, so this is an employment, this is A, In this A, one person is working, he met with an accident or he acquired the disease. So this person had a personal injury because of this accident or diseases, then this personal injury is called as employment injury, provided this employment is insurable. Matlab, the law is applicable to this employment. Now, whether the accident occurs or occupational disease is contracted within or outside the territorial limit of the country, India. So I am the employer. I have sent my employee overseas to work and he met with an accident. Would it be considered as an employment injury? Yes. Now, what do you mean by out of or in course of employment? Out of, rising out of. When employment itself is a reason, cause for my injury, that is out of. My injury was result out of my employment, means while I was, so let's say my work is to rotate this pulley. So when my work is rotating this pulley, I'm employed to do this work of rotation. So because of this rotating this pulley only, I had an accident. Or I'm working with a chemical. My work only involves chemicals. While working on the chemicals, I acquired some occupational disease. So my work itself was responsible for the injury, that is called as out of, in course of. Now I am working on this pulley. There are number of the people surrounding or working around me. All of a sudden, this pulley get disbalanced and get removed from its place. So other people also get injured. So these people are called as in course of, because for them the employment was not the result, the premises. Similarly, if I'm working with a chemical, while working with a chemical, other people who acquire the disease, who are not working with the chemical but are into that premises, acquire the disease, that is in course of. Or I was asked by my manager that today you go there and go and submit these papers in the office, governmental office. So while I was traveling, I was doing my office work, I met with an accident. That is in course of the employment. Is this clear to everyone? What is out of the employment? What is in course of the employment? Pooja, yes. When my work itself is reason. So I am teaching right now on laptop. Continuously working on laptop, my eyes get damaged. So my work itself has caused a damage to my eyes. This is out of, right? Chalo, let's move to the next. 9, employee. Section 29 defines employee. Any person employed for the wages in connection with the factory or the establishment on which this act applicable, who is directly employed by the principal employer, who is employed through by an immediate employer. So now we have establishment. He is the owner. So he would be called as an principal employer. This owner or occupier have given a contract to some person B. This contractor have hired few people. So for this person, contractor is immediate employer and A is principal employer. So a person either being working under the immediate employer or employed by the principal employer directly on any premises or the factories where this act is applicable would be called as an employee. Even if he is working under the supervision of agent who is employed by principal employer, then also he would be an employee. Or there is a condition that there is a person and this employee is with an principal employer, employed by the principal employer. Now this principal employer, company A, has some kind of agreement company B. So company A, this principal employer says that my labor or my employee will come and give the services for few days at your place. So services are temporarily lent. So lent on hire to the principal employer by the person with whom whose service are lent or lent hire has been in contract or service. So in this case, this person becomes an employer to whom the services are lent. The services are lent to B. So B would become principal employer. Includes any person employed for the wages on any work connected with administration of factory, establishment of any part, department, branch, purchase of raw material, distribution of sales or product, factory or establishment. Any work which is associated with the factory, either its administration, forming the department, management, branch, purchase of raw material, all are employee. But any person who is an apprentice, engaged in apprentice, would be called as an employee, but he should not be covered under the Apprentice Act of 1961 or the standing orders of the establishment. So two cases, if he is already covered, apprentice under 1961 Act and standing order, then he won't be an employee, otherwise he would be an employee. These all people are called as the employee who are not member of the Indian Naval, Military, Air Forces. Any person so employed whose wages, excluding the overtime, exceed such wages as may be prescribed by the central government. This is 21,000. Earlier it was, I believe, 15,000. Now it is 21,000. Okay. Anyone whose salary is above 21,000 won't be considered as an employee. Done? Is this clear? Everyone understood? Nishchay, Mantu, good afternoon and welcome to the class. Let's move to the next. Exempted employee, important. Which section? Section 210, clause 10 defines exempted employee. Now, what is exempted employee? Every person who have to take the benefit under the ESIC Act has to make a contribution, since this is an insurance. So insurance requires a contribution. But there are the employees who are not liable to pay the contribution. Such people are called as the exempted employee. Even if they are not making the contribution, they are getting the benefits. Such people are called exempted employee. Family's definition important. Who is family? For an insured person, spouse, minor, legitimate or adopted child, dependent. So either minor, either legitimate, but dependent upon the child. A child who is wholly dependent on the earning of insured person and who is receiving an education till she or he attains 21 years of age. Okay? 21 years of age means a person, his daughter or son, they are studying. So until and unless till the age of 21 years, they are studying. So till the 21 years, they are the family. Unmarried daughter, then a child who is infirm by the reason of any physical or mental abnormality or injury and wholly dependent on the earning of insured person as long as infirmity continues. So till the point of the time the person is infirm. Dependent parents is a family. In case of insured person is unmarried, his or her parents are not alive, minor brother or minor sister wholly dependent upon the earning would be called as family. Is this clear? Spouse, husband or wife, child, minor or minor, legitimate or adopted, child doing the studies, unmarried daughter, child who is infirm, mentally dependent, mentally abnormal, dependent parents. If the parents are not alive, minor sister and brother. They all are family. Section 212 defines factory. A factory is an establishment where the ESI Act would be applicable, as we studied in starting. So what is factory as per this law? Whereon 10 or more persons are employed on any one day in the preceding 12 months, doing any kind of manufacturing process with aid of power, 20 or more people working in manufacturing process without aid of power, but very, very important, does not include a mine subject to the operations of the Mines Act 1952 or a railway running shed. So mines, wherever the Mines Act 1952 would be applicable, those mines won't be called as a factory. And railway running shed will be not called as a factory. Immediate employer. Section 2, clause 13. Do I need to explain this? Would you be able to read it? So, A, main principal employer means owner of the company. He has given a responsibility either to the agent or the contractor. Okay? He would be responsible for getting the work done. So, this contractor agent is the immediate employer, or A has lent the service to B. So, B also can be called as an immediate employer. Done. It includes contractor, it includes agent, it includes the person or the services to whom the services have been lent. Insurable employment means a factory or the establishment where the act is applicable. Insured person, a person who is employed in an establishment and who is making a contribution to avail the benefit. So that is insured person. Managing agent, a person who is appointed by the principal employer or the employer or being acting as a representative of the employer to carry out the trade or business is called as the managing agent. But an individual manager who is subordinate to the employer, immediately subordinate to the employer, he won't be called as an agent. Managing agent would be separately appointed to take care of the business. Individual manager who is immediate to the employer won't be called as a managing agent. Manufacturing process, same meaning as defined under the Factories Act. Miscarriage, defined under the Maternity Act, the same definition it is there. Expulsion of content of the pregnant uterus at the period prior to or during the 26th week of pregnancy does not include any miscarriage causing, which is punishable under Indian Penal Code. Occupier, similar as defined under the Section 2N of the Factories Act. This is important. Partial, permanent partial disablement, permanent total disablement. 15A given in Schedule 2. Schedule 2, Part 1. This is Schedule 2, Part 2. Okay? What do you mean by permanent partial disablement? Two words that you have to always associate while dealing with partial or total disablement. Partial disablement means it reduces the capacity of earning, whereas total disablement completely incapacitate. Partial mein it reduces. Either this can be permanent in nature or temporary in nature. The partial disablement will always reduce the capacity, earning capacity of an employee wherever he was or he is capable of being employed. उसकी केवल कमाने की कैपेसिटी को कुछ टाइम के लिए रिड्यूस कर देता है, either permanently or partially. And all the injury which are specified in Part 2 of second schedule shall be deemed as a result in the permanent partial disablement. It's not Part 2, it's Part 1. Okay. Now, permanent total disablement, this says which completely incapacitate, means he is no more capable. His capacity is not reduced. He is no more capable of doing any kind of the work which he was able to perform during the accident or the diseases. Right? Provided the permanent total disablement shall be deemed to be result of every injury specified in Part 1 of second schedule and from the combination of Part 2 wherein. So now this says second schedule, schedule number 2, Part 1, Part 2. So this is partial and this is permanent. The combination of these two injury will be called as a permanent total disablement. Clear? ठीक है, ये वाला यहाँ पे ये सही है. This is schedule. This is given in schedule 1, but provided कि part 2 of this is given in part 1 of schedule 2, but schedule 2 के part 2 के जितने भी diseases हैं, they shall be deemed to result in permanent partial disablement. They all are considered to be permanent partial disablement. Is this clear? 15A and 15B. What term you have to use? That partial disablement will always reduce the capacity. ठीक है? Capacity. However, the total disablement will always incapacitate. Done? Yes, Garun. That is part 2 only. Seasonal factory. Very, very important. We studied in the starting that the act is applicable to these factories which are not seasonal, but not on seasonal. So what are seasonal factory? The factory which exclusively are engaged in any one or more following manufacturing process, like cotton ginning, cotton or jute pressing, decoration of groundnuts, manufacture of coffee, indigo, lac, rubber, sugar, good tea, or any manufacturing process. Any work incidental to all this process, and it include a factory which is engaged for the period not exceeding 7 months. बाकी जो लॉ आपने पढ़े हैं ना, प्रिवेंटिव जितने भी लॉ पढ़े 180 days, राइट? यही पढ़ा है ना. What is seasonal factory? 180 days. The factories where the work is not extending, is less than 180 days, would be called as seasonal. Here it is a period of not exceeding the 7 months in a year is called as the seasonal. Now this work would in any process of blending, packing, repacking of coffee, tea, or in such other manufacturing process as central government may by the notification tell. Is this clear? Baki laws में appropriate government decide whether it is seasonal in nature or not. Here central government would be deciding what all activities, what all work would be called as seasonal. 20. Sickness. Any condition which acquire the medical treatment and attendance and necessities the absenteeism from the medical ground from the work is called sickness. Section 2 clause 21 important, can be asked. What is temporary disablement? This is also temporary in nature. For the temporary period, a person becomes incapable of doing the thing. So a condition resulting out from an employment injury which require a medical treatment and renders an employee into a such temporary injury resulting him incapable of doing the work which he was doing prior to or the time of the injury. So this is temporary. Fracture ho gaya. It is temporary in nature. So it is like he is going through the medical treatment and it is the temporary injury which is not allowing or making him incapable for this temporary period. That is temporary disablement. Wages, important. Section number 222 defines wages. Include all remuneration paid or payable in cash to an employee where the terms of contract of employed were expressed, implied, or were fulfilled. This will also include any payment of an employee in respect to authorized leave, lockout, strike which is not legal, or layoff which is not illegal. Sorry, not legal, illegal. This is the ESI Act only which includes the wages of lockout period, layoff period, strike period, which are not illegal in nature, and authorized leave. Any other additional remuneration that is paid at the interval not exceeding 2 months. So any payment which is given every 2 months, every 1.5 months, that would be a part of wages. Does not include any contribution to the provident fund, pension fund by the employer, traveling allowance or the value of the traveling concession, any sum paid to a person employed to defray special expenses, any gratuity payable on discharge, that are not included. Wage period, in relation to an employee, a period irrespective to which an employee is ordinarily paid, right? It may be one, usually it is 1 month, it can be 15 days, 7, and so on. Section 2A important. Registration of the factories and establishment. Every factory or the establishment on which ESI Act applies, it will register itself under the Act as per the regulations specified. So we have rules, we have regulations. We study central rules, we even study regulations. So under ESI, the registration is done as per the regulations. Done? Next. Chapter 2. Corporation Standing Committee Medical Benefit Council. Section number 3, please by heart this section. It's talk about ESIC, Establishment of Employee State Insurance Corporation. Central government will establish Employee State Insurance Corporation for the administration of the schemes associated with ESI. This corporation would be called as Employee State Insurance Corporation. This body, it would be a corporate body by the name of Employee State Insurance Corporation, having perpetual means long succession. Common seal shall be by said name sue or sued. Clear? Next. Constitution of corporation is important. So what would be the members? Who would be the members? Chairman, who is appointed by central government. Vice chairman, appointed by central government. Not more than 5 members who are appointed by the central government. 1 person representing each state appointed by the state government. So whoever would be the state member, so each person from the state. 1 person appointed by central government to represent union territories. 10 person representing the employer appointed by central government. 10 person representing employees appointed by central government. 2 people from medical profession appointed by central government. 3 members of parliament, 2 from Lok Sabha, 1 from Rajya Sabha. Okay? Elected respectively by the member of House of the People, the member of Council of the State. So, and there would be a Director General of the corporation who would be an ex officio. So what it is? 1 plus 1 plus 5 plus 1 plus again 1 plus 10 plus 10 plus 2 plus 3 and plus 1. So 2, 7, 8, 9, 19, 29, 31, 34, 35. How many members are there? 35 members under this corporation. Chairman, vice chairman, 5 other members representing central government, 1 person representing state, 1 person representing union territory, 10 employer representation, 10 employee representative, 2 medical profession, 3 parliament, 2 from Lok Sabha, 1 from Rajya Sabha, and 1 Director General who would be an ex officio. Clear? Term and the term of office and the member of corporation. Except the chairman, vice chairman, and the 5 person appointed by central government, 1 representing state government, and 1 union territories, the ex and the ex officio, leaving all these people, all would be for the 4 years. The tenure is of 4 years, means 10 representative from employer, 10 representative from employee, parliament 3 members, Director General. So these 3 people, the tenure is of 4 years. Eligibility for reappointment or re-election. Yes. Any person whose term expires, 4 years expired, can he be reappointed or re-elected? Yes. Any member who is outgoing from corporation, standing committee, or medical benefit council can be reappointed. Authentication of orders and decisions. All the orders and the decisions which are made by ESIC, Employees Insurance State Corporation, they have to be authenticated by Director General. He will be signing, his signature would be there in all the decisions and the order, or any other officer of the corporation which Director General may authorize. Now, section number D, Constitution of Standing Committee. Who would be constituting it? Central government. What would be the members? Chairman appointed by central government. 3 members of corporation appointed by central government. 3 members of corporation representing the 3 state. So, whatever state representation were there, usme se 3 would be representing here. 8 member elected by corporation as 3 member representing employer, 3 member representing employees, 1 member among the members of corporation medical profession, 1 member among the members of corporation elected by parliament. So all these members are taken up from ESIC. Who is taken? Other than your chairman, who is appointed by the central government, 3 people of the ESIC who is representing central government, 3 people of representing the state government, okay, 8 members out of which 3 are employers representative taken up from corporation, 3 from employees representative taken from corporation, 1 medical profession, 1 elected from parliament, and 1 director general who would be the ex officio. Is this clear? Clear? Let's move to the next. Now my slide has stuck. What to do? Give me a second. Okay, is this slide visible? It's not working. I want to finish this, but the slide have stuck. Give me 2 minutes. It will start. Just a second, huh? I'm just refreshing. This is not moving. Whenever I think I would be completing, then it's like either slide gets stuck, either network makes an issue. I don't know why. Give me a second. I wanted to finish this today only because it's really taking time. Getting bored. Few days I will take. Okay, anyways, that's not starting. So we'll do it tomorrow. We'll finish it tomorrow. Okay. We'll finish this act tomorrow. And I don't know. The slide is not working. Okay, give me a second. Let me just refresh it. If it starts, it's well and good. If doesn't, so many things are opened here. Was the legislation clear? Now this is this is like okay. Let me check. What is the question that you have forwarded me? Any query, any question? Meanwhile, you can just ask me. Let me just check the question. Consider the question National Social Security Board and choose this statement which is not correct. This National Social Security Board, Garun, in relation to what? Unorganized. Unorganized. See, Anishchay, I told you, na, there is a copyright issue. I cannot. ठीक है. There are 34 members. The term of National Board is 5 years, shall meet twice in a year. Rules of the procedure relating to the transaction of business at the meeting shall be made by chairperson and secretary of the board. 34 members. National Social, 34 members are there. Wah, Pooja, impressed. Yeah, that's section 5, National Social Security Board. And then we have other section number 5 के बाद एक और है ना, एक और बोर्ड के बारे में. 28 स्टेट में होते हैं. यस. तो हु इज द एक्स ऑफिशियो? यूनियन मिनिस्टर ऑफ लेबर. यूनियन मिनिस्टर ऑफ लेबर. यस. सेकंड स्टेटमेंट इज आल्सो right. Term of national board is 5 years. This is not correct. What is the term? What is the term of national board? Twice in a year. all these statements, which of the following are not correct? Acha, not correct. Three years. So option number 3 is not correct here, and they should meet at least 3 times, means in a quarter. Term is 3 year, and in a quarter, at least in quarter once they have to meet. So third option is not correct. Then first wala nikal gaya, second. So option number third. ठीक है? Garun, option number third. I will share this question in the group. Thrice a year means quarter. At least thrice a year. 3 बार साल में मिलना, यानी क्वार्टर में 3 बार मिलना इज द स्टेट. I will go through this once. ठीक है, I have to end it, and the session will answer you the question. ठीक है, okay, fine. So that was the session for the day. We'll continue this tomorrow, and we'll finish up this ESIC. Yes, Ramanathan, I will answer this. I will go through it. Garun, I will go through it. I have to end. Lunch time. Have to cook. You know. Okay, fine. Thank you. Ask in English.